Welcome to Davis Malm. We're going to be covering a range of interesting topics that I hope will be informative and interesting to you.
All right, good morning, everyone. I'm going to be talking about AI in the workplace. This is sort of a topic that we're hearing more and more about in the news, and it does have some implications for employers that we wanted you to be aware of. So, what is AI? Broadly speaking, it is technology that enables machines to understand and analyze information in a way similar to how we as humans do so. It has a number of applications in the workplace. Some of you may have been using some of these tools already. Job applicant screening tools, so resume scanners. If you're hiring and you're getting a lot of resumes, this can be a way to cull through the volume. Some employers are using video interviewing and evaluation of candidates based on their facial expressions and their manners of speech, testing that assesses an applicant's fit, monitoring current employees using technology if they're working remotely. These are all some ways that employers are using AI. So a few things for employers to be particularly mindful of when using this technology. First are potential discriminatory uses of AI. First is disparate treatment. That's when an employer is intentionally discriminating against members of a protected category. So an example here would be an employer says, I'm not hiring any women for my accounting department. I only want to hire men. That's disparate treatment, intentional discrimination against a protected group. Disparate impact is when you have a facially neutral policy that ends up having an impact on a protected group, even if that isn't necessarily the intent. So an employer says, I only want to hire people who are over 6 feet tall for my accounting department. So women tend to be shorter than men. That policy, although it's not expressly saying no women need apply, it is going to have an impact disproportionately on female applicants. So how does this dovetail with AI? The same prohibitions that against discrimination in the sort of normal context also apply to employers' use of AI. The EEOC has issued guidance that says that AI can violate prohibitions against disparate impact discrimination if the tool has an adverse impact on individuals of a particular protected category. The employer can't show that the use of the tool is related to the job and consistent with business necessity, and a less discriminatory tool was available but not used. So essentially, you can be liable for discrimination based on your use of an AI tool, even if no humans are making any decisions or policies. And employers can also be liable for disparate impact that results from their use of AI tools from a third-party vendor. So it's not sufficient to say, I subscribe to this platform or this software that's available from another company. If you as an employer are using it and it has a disparate impact on people in a particular group, you could be potentially liable. So how does this happen? Because AI sort of learns based on the information that it's provided with. And so if you have potentially some bias that's going in, then that's what the AI tool is going to learn, and it may result in bias in the output of the program. So just to give a couple of examples, these are real world examples. There was a big technology company used an AI resume scanning tool for applicants for software engineers. So the tool was trained using resumes from current software engineers. The company liked their current employees. They wanted people who had similar experience and backgrounds. And the tool, based on the largely white male current group of employees, the tool learned to downgrade applicants who had went to women's colleges, resumes that included the word women. The most favorable applicants, according to the tool, were people whose name was Jared and people who had played high school lacrosse. So another example is an HR company who developed facial recognition tools to use in pre-employment assessments of candidates. An FTC complaint was actually filed alleging that the tool was racially biased because it read black faces as more angry than white faces. People with certain disabilities who don't tend to make eye contact, or from cultures where eye contact is not favored, those people were also disproportionately disfavored by the tool. And so the company ended up agreeing to pull it from the market. So those are just some examples of how you need to be aware of discrimination claims if you're using some of these tools. Really want to make sure that they've been tested and proven not to have potentially disparate impact results. Another area where AI comes into play is wage and hour issues. So just a reminder, the Fair Labor Standards Act, federal law that governs wages, requires payment for all time that the employer knows or has reason to know that work is being performed. And the burden is on the employer to be aware of when the employees are working, to have records, and to pay them for their work time. So especially with remote workers, a lot of employers are using these tools to measure keystrokes, eye movements, internet browsing. That's how they're checking that people are working. The problem with these tools is they don't necessarily account for all of people's actual work time. If they're on the phone, they step away from their computer, they're looking at paper documents, they're out at a meeting with clients or colleagues, that may not be captured by the remote monitoring tools. So if the tool is deducting work time based on its misperception that people are not working just because they're not at their computer, that can result in FLSA violations according to the Federal Department of Labor, if the company ends up not paying people for all of the time that they're actually working. So if you're using tools like this, it can be a good starting point, but you want to make sure you're doing more to understand when are people actually working, and so you can pay them for that. A few other ways that AI can impact employers: risks of disclosures of intellectual property and confidential information. So if you have employees who are using ChatGPT or other chat-based AI platforms to do their jobs, if they are disclosing confidential company information and asking their question or saying, please write me a memo about XYZ, and in the process of doing that, they're giving away company information, the AI tool is going to learn that information that the employee has provided, and there's a potential that the AI program will provide that information to the next person who comes with a ChatGPT question. So you need to make sure that employees are not improperly disclosing material that they should not be to these tools. There's also a risk of inaccurate information that employees may obtain from AI tools. So I think, a lot of these platforms are pretty good, but they're not 100% accurate all the time. And if employees ask a question, they get an answer, it's not actually the right answer, and they improperly rely on that, that can lead to problems as well. This is a new technology. The law is pretty slow generally in sort of catching up to the modern world, but the same rules still apply. Discrimination, protections, wage and hour, confidentiality, these are familiar concepts to you as an employer, and you need to be mindful of how the new technology may impact your compliance with these issues. So AI is helpful, can't replace human beings quite yet. We still need to have oversight and understanding of what these tools are doing. And we do recommend that you implement policies around how these tools should be used.